Hi, greetings, friends. Jacque Howard here, the VOBC, the voice of Black cannabis. Thank you for taking your time to spend it with me and the guests that I'm bringing on to the program. This is going to be a bit of a series that will probably be aired through multiple outlets, but make sure that you check out the cannabis and hemp conversations that are happening on the Trenton cannabis community page on Facebook, but also make sure that you head over to the website black-cannabis.com and also jacques.com. There we're going to be keep recirculating this information under the idea of getting people as much information and access as possible about the things that are happening in our community. And I'm talking about specifically New Jersey right now and the central New Jersey region. I'm going to be bringing on Bill Riback, who is an Esquire or a lawyer, and he's going to be talking about a couple of cases that he's working on that are specifically involving cannabis, people of color, etc. But we're going to have Bill introduce himself. Bill, it's a pleasure to see you. I hope that everything is well on your side. Please introduce yourself and tell the folks a little bit about you, about your law practice, and then we'll talk a little bit about some of the cases that you've been sharing with me and the others in the Black Cannabis Network.
Good morning, Jacque. Bill Riback. I'm an attorney in Cherry Hill, New Jersey. Started practicing somewhere around in New Jersey around 1995. My practice is exclusive to plaintiffs, meaning the person who is suing the other party, and my practice is limited to suing governments and corporations, primarily for civil rights violations.
Great. And Bill, when we talk about that, I know there's a lot of times people will hear terminology that they class action lawsuits, or they may hear of some ideas about like suing. Can you break down specifically like the type of law that you're focusing on?
Right. So class actions are when there's a practice or a policy that's common to a group of people, more than 40, could be 100,000, could be in excess of 100,000, where the recoveries tend to be smaller. So a person who loses, let's say, $1,000 isn't going to be able to find a lawyer for him or her to sue to recover $1,000. And that's where the class action comes in, where you aggregate 10,000, 100,000 people for $1,000, and then it becomes a matter where the attorney has going to put a lot of time and resources and energy, because he's not suing for $1,000. Now he's suing for in excess of 7 and 8 figures, 9 figures. And so that's what a class action is. Mm-hmm. And I'm primarily doing class actions, although I do represent individuals on some cases, and my practice is limited to a very few number of cases.
So when we talk about the number of cases that you, Bill Riback, Esquire, attorney out of Cherry Hill, New Jersey, that you focus on, is there a particular segment or a particular, I don't even know the right word, like, subject matter that you like to focus on for your cases, or an area of expertise?
So what I'm primarily focused on in the class action arena is civil rights, meaning when the government does something using its state authority or its governmental authority to deny people their rights. So for one example is strip searches in county jails in New Jersey. For example, the county jails are not allowed to strip search individuals coming in on non-indictable offenses, for example, child support, traffic, things which are not indictable. 6 months. Indictable meaning it would go before a grand jury for an indictment. It would be more than 6 months of potential prison or jail time. So, and what we found is that county jails were routinely strip searching individuals all over the state. So that's winding down, but I was doing that for like 10 years. I have a case in Salem County where they were actually videotaping women being strip searched, where male correction officers could watch it. That's an ongoing case. Another example, more germane to this conversation, is the fines that were levied against persons who were convicted of possession of cannabis offenses, which were recently vacated and expunged, but no money was returned to the individuals. And so that's a case I'm working on right now. It's trying to get return of the fines and costs. And so there's a case on point actually from 2017, which was a United States Supreme Court case, Nelson versus Colorado, where two individuals sought to get their fines and costs back after they were found guilty through a trial, and then through an appeal, they paid their fines, and through an appeal they had won and got their conviction overturned, right? So the Supreme Court said or held that a person whose conviction is overturned is entitled to their money back. And that goes back 600 years back to England, where if you get your conviction overturned, you're entitled to your money back. Colorado was an outlier, was an unusual case where every other state said that if you got your conviction overturned by a court, you're entitled to your money back. Here it's not a court, so that's the difference. But I think it's the same thing, because the legislature, the governor, and the court have all, by statute, overturned the convictions. And my view is that they've actually exonerated or found not guilty. You don't need to be innocent to get your money back in these Nelson v. Colorado cases. You just needed to have it overturned, and the presumption of not guilty returns to you. Here, I think that it's even more powerful on the plaintiff's side, because the state really has admitted that the civil rights of persons who were arrested, people of color, but Black persons were arrested 3 times more than Caucasians, yet their usage is and was the same, right? So they admitted that it was in the law, you can infer that the state admitted that their civil rights of people of color were violated. And when we say it was 3 times, Black people were 3 times more likely, that's really an understatement, because in the data, the Hispanics are counted as white. So when you extract the Hispanics and you put them in people of color, I don't know exactly what the number is, but it's substantially more than 3. I don't know exactly what the number is. It's probably 5 to 6 times when you say people of color versus actually exclusively white non-Hispanic. It's probably 5 to 6, although I haven't worked that. John Getman, who actually did the 2013 study for the ACLU, who brought that out, and the state's using that study as an expert in working on the case here. So that's going to be one of the main focuses of this case, is that the class is just entitled to their money by nature of what I say is the exoneration or the overturning. I'm not sure how the state's going to have to distinguish the state doing it and there's no comparison to anything else. There's never been a statute that I know of where the state says, well, we violated everybody's civil rights, we're going to throw it out. Usually it's a court that comes in and says that and overturns an individual case. Although in Massachusetts, there was like 2,000 or 3,000 individuals whose guilty findings were overturned because a lab was found to have been violating people's civil rights.
You know, Bill, I want to jump in because you know I know that we're not going to spend too much time, and this is going to be one of many conversations that we're going to have going forward. I'm speaking with Bill Riback, who is an Esquire. Bill Riback Esquire, who is an attorney based out of Cherry Hill, New Jersey. He's been practicing since 1995. Bill, I'd like for you to take us down the lane of having proper legal representation and why it's important. And also on a larger scale, like if you feel as though you're part of something that is bigger than just you, like a class action thing, why it's so important to be aligned with proper legal representation.
Well, I can't emphasize enough. Alignment is in class actions. One of the requirements is alignment of the class counsel with the class. There's a lot of shenanigans that could go on where a lawyer can get paid for not doing his job. Like, for example, the coach of, I don't know who he was coaching, Flores, who's suing the NFL in a class action. It's not a counsel issue, but it's a coaching issue. He was told to lose cases. Not lose cases, lose games to improve the draft position of whatever team he was coaching. The same thing could happen with an attorney, that he could, you know, diminish or destroy the rights of his clients in order to get paid. Now, I'm not saying that's a rule that happens. Most class action attorneys are from the heart representing their clients, and that the more you get your clients, the more respected you're going to be in the legal community, and the ability to say that you're, in future cases, that you are adequate class counsel. But you can't, in individual cases and in class actions, alignment of interest is so important. And actually, Jerry Spence, one of the, no, not one, probably the best lawyer in millennia, if not decades, if not millennium. I don't think he's ever lost a case, which is astonishing. And I'm talking about like hard, difficult cases where the FBI shot and killed or shot people, and so his rule is that you have to live with your client, and he takes that as a rule, meaning to say that you're not, your job is to be the voice of your client. It's not to, he takes it to the point that you are your client. You're not, there's no daylight between you and your client. And so if you have that, you have passion. And if you have passion, you're going to do everything you can to get the result that your client wants.
Oh, that's fantastic. You know, I find things like this very intriguing to me because I don't know a lot about it, but it's such a major impact on all of our lives. And I think that culturally, we need to have more people understand how the legal system and how as lawyers and attorneys can work to help develop the community or work to not develop the community so much. There's a couple of cases. I just want you to touch on these next couple of minutes that you've been talking to me about and so forth. Can you just touch on those, and we'll go from there.
So I touched upon the strip search cases, right? And I've also touched upon the cannabis case I'm working on. The other piece of the cannabis case is the school zones. The school zone, so school zones, because distribution under an ounce has been expunged and vacated, but distribution under an ounce in a school zone has not. The only difference is of the offenses is one occurs in a school zone and one does not. And what does that mean in reality is one offense occurs in Newark, Camden, Jersey City, Passaic, cities, inner cities. And why does that happen? Because inner cities are much more populated per square mile than, say, Deerfield or wherever, whatever rural town or even suburban, Cherry Hill. I'm going to say Cherry Hill has, on average, 2,000 people per square mile, whereas Newark, Jersey City is 16,000 people per square mile. So 2,000 people per square mile versus Jersey City, 16,000 as an example of a city, which Newark is pretty much probably like 12,000 people per square mile. So what does that mean? It means that schools are everywhere in Newark, Jersey City, Camden, Passaic, blah, 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 blah. What happens is it's supposed to be within 1,000 feet of a school zone, right? But Jersey City and the cities are their entirety a school zone, which means that if you live in a city and you distribute within, in a city, you have a 10,000 foot school zone. And if you're distributing in a city, so you are guilty of a school zone. School zones are much more harsh. A first offense for a non-school zone or regular distribution right now, you get a verbal warning, whereas for a person of color living in a city, you're facing a criminal charge for a first offense. It was even worse prior to the Modernization Act of what 2021. It started out that it was a mandatory 1 year in prison, then it's shifted to a presumptive 1 year in prison. But the bottom line is you couldn't get a diversion. So you ended up with a criminal record if you're a person of color distribution in a school, in a city. So that's another piece of that cannabis case that I'm working on. I got a guy, a gentleman who was deported from the United States as a Jamaican back to Jamaica because he was distributing less than an ounce. You're talking about dime bags or whatever. So he gets deported and he can't come back to the country. And unfortunately, the state won't, at this point, doesn't see the merit in this argument. I'm not sure what they're seeing. And then the other one that I'm trying to work on, which I do not have a client, is a case against the oil majors, Exxon, BP, who, you name a major oil company, and they're in the mix. So there's about 12 of these cases going on. And they're suing the oil majors for greenhouse gas, for what some people call global warming. I call it climate catastrophe. It's enlightening that most people don't know, even people who I would think would know, but don't know. People who I even think legislators don't even know that there's something called the Thwaites Glacier it's way up north in the Arctic. It's an enormous glacier, but it's sitting in the water. And what they're finding is that it's melting much. We thought it would be decades from now. It's not decades from now. They came out and said it's going to be in 5 to 10 years. And what the consequence of that is that the ice that lies behind the Thwaites Glacier is going to, in turn, melt. And that causes profound, disastrous consequences of a 2-foot sea rise within the next 25 years, which is 1 inch per year, which may not sound a lot, but it's absolutely, there's no comparison in the last 3 million years that something like this has happened. So I would have to think that this is going to be catastrophic. And shockingly, Exxon knew back in the Minnesota Attorney General, Ellison, I read his complaint, and Exxon knew from 1950 that this would happen. And the most troubling paragraph in that 60, 70 page complaint is that someone from Exxon said that by the time we find out, it will be too late. So we have found out. So unfortunately, we're not doing everything we should be doing, and maybe the answer is going to be a case. And there are very, very highly competent lawyers working on this, much, much above my level. But hopefully we'll get some action going, more action going on. Hoboken's already suing with, Baltimore is suing, Minnesota's suing. There's municipalities out in California.
Yeah, I want to jump in there just to, for sake of time, et cetera, just so I know this. So Hoboken, Baltimore, you said some California cities. So is this an opportunity for any municipality that's located on a body of water? Is this an opportunity for them to get involved in this lawsuit about the Thwaites Glacier and the big four or the big majors in oil?
The best, I think the best plaintiffs or the best cities that would represent would be municipalities on water that have already been harmed, such as Hoboken. It was the one of the hurricanes. I'm not sure which one it was, but yeah, certainly the bodies of water. But the municipality of Boulder is a case that was just got a very good outcome in a part of its case that said that the case has to be litigated in state court. But I don't think Boulder is on a body of water. So it could be glacier melt. It could be drought. We're experiencing an enormous drought out west. So, but for purpose of New Jersey, it's probably a body of water.
So a city like the river cities, Trenton, Camden, Frenchtown, Lambertville, all of those could be potential, municipalities that you think could be a part of this.
I would think they've already experienced flooding, and certainly the Atlantic City, Ventnor, Margate, they routinely, just high tide, they get swamped. And I saw some articles that said that the Hurricane Alley is going to shift north. So New York and our region is we don't get that many, we're not like Florida getting 6 or 7 hurricanes in a season, but that is subject to change.
Great. Well, William, Bill Riback, thank you so much for your time. I appreciate you coming on, sharing a bit about this. We look forward to having you come back on a regular basis and talk about some of the cases, to encourage people to be involved in the legal process and to keep their eyes and ears open about what's happening oftentimes in the shadows that really has an impact on each other's lives. Okay?
That would be my pleasure. And thank you so much for having me, Jacque.
As always, Bill, nice chatting with you.
And there,
sure thing. And there you have it, folks. Another conversation with another person in my network that has a skill set that I don't have. And I'm cool with bringing them on and giving them an opportunity to share some thoughts and concerns and ideas and things that they have. Now, I also have to say this because it's a disclaimer. The opinions of the guests that we have on are not necessarily the opinions of IMJPH, Jacque Howard, Black Cannabis, or Trenton 365 and the Trenton cannabis community. However, we provide these opportunities for you to come and listen and hear what else is out there, and to encourage you to reach out to them and be a part of building a better community for everyone. Until we meet again, remember, it's always about justice, peace, and humility.